Legal disclaimer: this podcast episode is for educational and entertainment purposes only. The information provided does not constitute legal advice, and no attorney-client relationship is formed by listening to this podcast. Always consult with a qualified legal professional for specific legal guidance. Howdy, Lone Wolf Pack. I'm Equity Ed, your guide through the labyrinthine world of equity jurisprudence. Today, we're embarking on an in-depth exploration of a topic that's as intricate as the finest embroidery, guardianship, and the legal concept of abandonment. Hold on to your hats because we're going to dig deep into legal texts, compare sources, and uncover the nuances that could make or break a legal case. Let's start this legal rodeo. Guardianship. Legal protections and fiduciary responsibilities. Guardianship is a foundational concept in law that is designed to protect those who cannot care for themselves, typically minors, elderly individuals, or those with incapacitating conditions. The guardian is entrusted with the responsibility of managing the ward's affairs, which may include financial management, healthcare decisions, and ensuring overall welfare. However, with this significant responsibility comes the necessity of strict legal oversight to prevent abuse and ensure that the guardian acts in the best interest of the ward. In this discussion, we will analyze how three key legal sources, Bouviers Law Dictionary, 1856, Anderson's Law Dictionary, 1889, and Corpus Juris Secundum, 1928, define and elaborate on the legal protections for wards. We will also delve into the legal intricacies of abandonment, a concept that, in the context of guardianship, has significant ramifications for both the guardian and the ward. Bouvier's Law Dictionary, 1856. The court as the protector of wards. Bouvier's Law Dictionary, one of the most authoritative legal references from the 19th century, underscores the court's critical role in guardianship. According to Bouvier, the court is not merely a passive overseer, but an active protector of the ward's interests. The court holds the power to remove a guardian who fails to perform their duties or who acts contrary to the ward's best interests. Bouvier, 1856, p. 305. This is a crucial legal mechanism that ensures the ward's rights and well-being are safeguarded against potential misuse or neglect by the guardian. For instance, if a guardian is found to be embezzling funds from the ward's estate or neglecting their duty to provide for the ward's basic needs, such as food and medical care, the court can step in and appoint a new guardian who will act responsibly. Bouvier's emphasis on the court's protective function highlights the legal system's commitment to upholding justice and providing a safety net for those who are most vulnerable. Furthermore, Bouvier's Law Dictionary recognizes the court's authority to hold guardians accountable for their fiduciary duties. The guardian-ward relationship is, at its core, a fiduciary one where the guardian is legally obligated to act in the best interests of the ward. This relationship is akin to that of a trustee and beneficiary, where the trustee must manage the trust's assets with the utmost care and loyalty. Similarly, a guardian must manage the ward's affairs with the highest standard of care, ensuring that every action taken is for the benefit of the ward. Bouvier's perspective on guardianship is deeply rooted in the principle that the law must actively intervene to protect those who cannot protect themselves. This intervention is not limited to reactive measures, but includes proactive oversight, ensuring that the guardian's actions are continuously monitored and evaluated by the court. Example in practice: consider a case where a guardian is responsible for managing the financial assets of a minor. If the guardian decides to invest the ward's assets in a high-risk venture without considering the potential impact on the ward's future, the court can intervene. The court may require the guardian to provide a detailed account of the decision-making process, and if the actions are found to be imprudent, the court may replace the guardian. This level of oversight is essential in preventing the guardian from taking actions that could jeopardize the ward's financial security. Bouvier's emphasis on the court's protective role and the accountability of the guardian ensures that the legal system functions as a guardian of last resort, stepping in whenever necessary to protect the interests of the ward. Anderson's Law Dictionary, 1889, a broader perspective on guardianship. Anderson's Law Dictionary, another authoritative source from the late 19th century, aligns with Bouvier's view on the court's role in guardianship, but adds a broader perspective by emphasizing the holistic responsibilities of the guardian. According to Anderson, guardianship is not just about managing the ward's financial affairs. It encompasses a wide range of duties that are essential for the ward's overall well-being. Anderson, 1889, pq 310. Anderson highlights that guardians are responsible for making critical decisions about the ward's education, healthcare, and general welfare. This approach ensures that the guardian's duties are not limited to financial management, but also include providing for the ward's physical, emotional, and social needs. By adopting this holistic approach, Anderson's Law Dictionary emphasizes that the guardian must consider all aspects of the ward's life and make decisions that promote the ward's best interests in a comprehensive manner. For example, if a guardian is tasked with caring for a minor, they must ensure that the child receives a proper education, has access to necessary medical care, and lives in a safe and nurturing environment. These responsibilities go beyond mere financial management and require the guardian to act as a caregiver, protector, and advocate for the ward. Anderson also underscores the importance of the court's oversight in guardianship matters. Guardians are accountable to the court for their actions and must regularly report on their management of the ward's affairs. This reporting requirement serves as a safeguard, ensuring that the guardian's decisions are transparent and that any potential issues can be identified and addressed promptly. Example in practice: imagine a scenario where a guardian is responsible for a ward with special needs. The guardian must not only manage the ward's financial assets, but also make decisions about the ward's medical care, educational needs, and daily living arrangements. The court's oversight in this case is crucial in ensuring that the guardian is fulfilling all aspects of their duties. Regular reporting to the court allows for ongoing monitoring of the guardian's actions, providing a layer of protection for the ward. Anderson's approach to guardianship reflects a deep understanding of the complexities involved in caring for individuals who are unable to care for themselves. By recognizing the multifaceted nature of guardianship, Anderson's Law Dictionary provides a comprehensive framework for understanding the responsibilities and legal obligations of guardians. Corpus Juris Secundum, 1928, a detailed framework for legal protections. Corpus Juris Secundum, CJ, published in 1928, offers the most detailed and practical perspective on guardianship among the three sources discussed. CJ 1928 builds on the foundational principles outlined by Bouvier and Anderson, but goes further by providing a comprehensive legal framework for monitoring and enforcing guardianship duties. One of the key contributions of CJ 1928 is its emphasis on regular reporting requirements and the legal consequences for guardians who fail to fulfill their duties. According to CJ 1928, guardians are required to submit periodic reports to the court detailing their management of the ward's affairs. CJ 1928, Guardian and Ward, Section 46. These reports allow the court to closely monitor the guardian's actions and intervene if necessary. For instance, if a guardian is found to be mismanaging the ward's financial assets or neglecting their duty to provide for the ward's basic needs, the court can take corrective action. This may include removing the guardian and appointing a new one, requiring restitution for any financial losses, or even pursuing criminal charges in cases of fraud or embezzlement. CJ 1928's detailed approach to legal protections ensures that guardians are held to the highest standards of integrity and responsibility. In addition to regular reporting, CJ 1928 discusses the court's role in the initial appointment of guardians. The court must carefully evaluate potential guardians to ensure that they are capable and trustworthy individuals who will act in the best interest of the ward. This proactive approach helps prevent issues from arising by ensuring that only qualified individuals are appointed as guardians. Example in practice. Consider a case where a court is tasked with appointing a guardian for an elderly individual who can no longer manage their own affairs. The court must thoroughly vet potential guardians, considering their background, experience, and ability to manage the ward's complex needs. Once a guardian is appointed, the court requires regular reports on the guardian's actions, ensuring ongoing oversight and accountability. CJ 1928's emphasis on accountability and proactive oversight provides a robust framework for guardianship, ensuring that the ward's interests are protected at every stage of the process. By requiring regular reporting and emphasizing the importance of the court's role in both the appointment and ongoing monitoring of guardians, CJ 1928 offers a comprehensive guide to how guardianship should be implemented in practice. Comparative analysis, diverging approaches to guardianship. When comparing Bouviers Law Dictionary, Anderson's Law Dictionary, and Corpus Juris Secundum, it becomes evident that while all three sources share common principles regarding the fiduciary duties of guardians and the court's protective role, they differ significantly in their approach to the practical implementation of these principles. Bouvier's reactive approach. Bouvier's Law Dictionary focuses on the court's authority to intervene in cases where a guardian fails to act in the ward's best interest. This approach is primarily reactive, dealing with issues as they arise. The emphasis is on the court's power to remove and replace guardians who are found to be negligent or abusive, ensuring that the ward is not left unprotected. Anderson's holistic view. Anderson's Law Dictionary takes a broader perspective by emphasizing the holistic responsibilities of the guardian. Anderson's approach goes beyond financial management to include the ward's overall welfare, highlighting the importance of making decisions that address all aspects of the ward's life. While Anderson also recognizes the court's oversight role, the focus is on the comprehensive nature of the guardian's duties rather than on specific legal mechanisms for enforcement. CJ 1928's proactive and detailed framework. Corpus Juris Secundum offers the most detailed and proactive approach, providing a comprehensive legal framework for both the appointment of guardians and the ongoing monitoring of their actions. CJ 1928 emphasizes the importance of regular reporting, accountability, and the court's role in preventing issues before they arise. This detailed approach reflects a deeper understanding of the complexities involved in guardianship and the need for ongoing oversight to ensure that guardians fulfill their responsibilities. Summary of comparative analysis. While Bouvier and Anderson provide valuable insights into the theoretical aspects of guardianship, CJ 1928 offers a more practical guide to how these principles should be implemented in practice. CJ 1928's detailed legal framework ensures that guardians are held accountable for their actions and that the ward's interests are continuously protected through proactive oversight and regular reporting. Abandonment, legal ramifications and responsibilities. The concept of abandonment is a multifaceted legal issue that requires careful consideration of intention, action, and the consequences that follow. Abandonment can occur in various legal contexts, including property law, guardianship, and even personal rights. Understanding the legal ramifications of abandonment is essential for both guardians and wards, as well as for property owners and those responsible for managing others' affairs. Bouvier's Law Dictionary, 1856, Formal Aspects of Abandonment. Bouvier's Law Dictionary emphasizes the formal aspects of abandonment, focusing on the need for clear intention and decisive action. According to Bouviers, abandonment occurs when an individual intentionally and voluntarily relinquishes a right, property, or duty without the intention of reclaiming it. This definition highlights the importance of intention in determining whether an act constitutes abandonment. For example, in property law, abandonment might occur when a property owner leaves a property with no intention of returning, effectively relinquishing their ownership rights. However, the key element in Bouvier's definition is the owner's intention. If the owner intends to return or does not clearly express their intention to abandon the property, the act may not legally constitute abandonment. Bouvier's definition also underscores the significance of action in the abandonment process. Simply having the intention to abandon is not sufficient. The individual must also take decisive action that reflects this intention. This combination of intention and action is crucial in determining whether abandonment has occurred and what legal consequences may follow. Example in practice. Consider a case where a landowner leaves their property vacant for an extended period, without any maintenance or oversight, and without any plans to return. If the landowner's actions indicate a clear intention to abandon the property, such as not paying property taxes or refusing to respond to inquiries about the property, the court may determine that the property has been abandoned. This could lead to the property being claimed by another party through adverse possession, a legal doctrine that allows individuals to acquire ownership of abandoned property. Anderson's Law Dictionary, 1889, The Role of Intention in Abandonment. Anderson's Law Dictionary aligns with Bouvier's view on the importance of intention in abandonment. Anderson emphasizes that abandonment requires a clear and deliberate intention to relinquish a right or duty. This focus on intention ensures that abandonment is not inferred from ambiguous or uncertain actions. For instance, in the context of guardianship, a guardian who fails to fulfill their duties due to negligence or incompetence may not be considered to have abandoned their responsibilities unless there is clear evidence of their intention to do so. This distinction is important in protecting the rights of both the guardian and the ward, as it prevents the court from prematurely assuming abandonment without sufficient evidence. Anderson's approach to abandonment also highlights the legal consequences of such an action. Once abandonment is established, the individual who abandons their rights or duties may lose the ability to reclaim them. This irrevocability underscores the seriousness of abandonment as a legal action and the need for individuals to carefully consider their intentions and actions before proceeding. Example in practice. Imagine a scenario where a guardian is responsible for a minor but has moved to another state without making provisions for the minor's care. If the court finds that the guardian intentionally abandoned their responsibilities, the guardian may be removed and a new guardian appointed. The original guardian may also lose any legal rights they had over the ward, including the right to make decisions on the ward's behalf. Corpus Juris Secundum, 1928. Practical implications of abandonment. Corpus Juris Secundum takes a more detailed and practical approach to abandonment, considering not only the formal aspects but also the broader implications of the act. CJ 1928 discusses how abandonment can impact various legal contexts, including property law, maritime law, and guardianship. In property law, CJ 1928 notes that abandonment can lead to the loss of ownership rights, with the property potentially being claimed by another party through adverse possession. This practical consideration highlights the risks involved in abandoning property without considering the potential consequences. In the context of guardianship, CJ 1928 discusses how abandonment by a guardian can have serious implications for the ward. If a guardian abandons their responsibilities, the court may need to intervene to protect the ward's interests, potentially leading to the appointment of a new guardian. This proactive approach ensures that the ward is not left without adequate care and protection. CJ 1928's emphasis on the practical implications of abandonment reflects a broader understanding of the complexities involved in such an action. By considering both the formal aspects of abandonment and its potential consequences, CJ 1928 provides a comprehensive guide to navigating this challenging legal issue. Example in practice: consider a case where a ship owner abandons a vessel at sea, leaving the crew and cargo at risk. Under maritime law, this act of abandonment could have severe legal consequences, including the loss of ownership rights over the vessel and potential liability for any harm caused to the crew or cargo. CJ 1928's detailed analysis of abandonment in this context underscores the importance of understanding the legal ramifications of such actions. Conclusion: the complexities of guardianship and abandonment. The analysis of Bouviers Law Dictionary, 1856, Anderson's Law Dictionary, 1889, and Corpus Juris Secundum, 1928, reveals both the commonalities and differences in how these sources approach the concepts of guardianship and abandonment. While all three sources agree on the importance of protecting wards and the significance of intention in abandonment, CJ 1928 offers a more detailed and practical perspective on how these legal principles should be implemented in practice. Bouvier and Anderson provide valuable insights into the theoretical aspects of guardianship and abandonment, focusing on the formal requirements and the importance of intention and action. Their emphasis on the court's role in protecting wards and the legal consequences of abandonment highlights the foundational principles that underpin these legal concepts. In contrast, CJ 1928 takes a more practical approach, providing detailed guidance on the legal mechanisms available to the court for monitoring and enforcing guardianship duties, as well as the potential consequences of abandonment. This comprehensive perspective reflects a broader understanding of the complexities involved in these legal issues and the need for ongoing oversight and accountability. As we have seen, guardianship and abandonment are not merely legal formalities. They involve significant responsibilities and consequences that must be carefully managed. Whether you are a guardian, a property owner, or someone navigating the complexities of legal rights and duties, understanding these concepts is essential to making informed decisions and protecting your interests. Well, Lone Wolf Pack, that's all she wrote for today's exploration of guardianship and abandonment. Remember, the law is like a finely tuned instrument. It requires precision, care, and a deep understanding to play it right. So whether you're out there navigating the wild frontier of legal rights or just keeping your nose clean, stay informed, stay sharp, and as always, keep howling at the moon. Until next time, may your equity always be